Start. Heard. Learned counsel for the parties. Full stop para. This is an appeal against the order of learned single judge dated 12.1.2007 passed in writ petition number 54523 of 2005, whereby learned single judge has dismissed the writ petition being devoid of merit. Full stop para. Appellant was Amin in Bareilly judgeship. Full stop. In February 1994, a complaint was made that the appellant, while performing his duties as Amin, took rupees 50 as expenses and demanded rupees 500 by way of bribe. Full stop. On the complaint being made, an inquiry was made and the appellant was awarded punishment of stoppage of 2 increment permanently. Full stop. Against the said order, the appellant filed statutory appeal before the Honorable Administrative Judge, Bareilly Judgeship. Full stop. The then Honorable Administrative Judge, Bareilly Judgeship allowed the appeal in part and reduced the punishment to the stoppage of 2 increments for 5 years only. Full stop. Against the said order, the appellant filed writ petition number 26996 of 1999, which has been allowed wide order dated 6.8.2013, whereby the punishment order has been quashed and the disciplinary authority has been directed to consider the matter afresh to grant any lesser punishment. Full stop. The copy of the order of learned single judge passed in writ petition number 26996 of 1999 has been filed along with the amendment application. Full stop. The appellant has been subjected for consideration of the compulsory retirement by the screening committee. Full stop. The screening committee, having regard to the material available on record, has recommended for the compulsory retirement of the appellant. Full stop. Thereafter, on the recommendation of the screening committee, District Judge, Bareilly, in exercise of powers vested in Fundamental Rules 56 in bracket C bracket out of the Financial Handbook Volume 2, paras 2 to 4, compulsorily retired the appellant wide order dated 15.7.2005, which has been challenged by the appellant in writ petition number 54523 of 2005. Full stop. The learned single judge, while deciding the aforesaid writ petition, observed as follows: para. In the present case, factual position which is emerging is to the effect that at all point of time, work and conduct of petitioner has been found to be satisfactory / good, except for the year 1993 to 94, while preparing ACR of petitioner, it has been mentioned that work is satisfactory, but members of bar have complaints qua the functioning of petitioner. Full stop. On 17.7.1995, charges of accepting bribe and demanding rupees 500 has been found proved and petitioner has been declared unfit to work as Amin, and requisite entry has been made in this regard on 29.7.1995 by District Judge, Bareilly, and thereafter pursuant to order of this court, entries have been made mentioning that appeal of petitioner has been dismissed and punishment shall operate for period of 5 years and not permanently. Full stop. Only ground on which petitioner has been compulsory retired is that complaint was made against petitioner for accepting bribe of rupees 50 as expenses and making demand of rupees 500 in suit number 14 of 1994 Badlu Khan and others versus District Cane Officer and others while working as Amin, and said charges were found proved in inquiry and punishment was awarded to petitioner on 24.7.1995, and against the imposition of said punishment, statutory appeal had been preferred before the administrative judge of this court, and said finding has been affirmed, and only punishment which has been awarded has been modified by mentioning a stoppage of 2 increments for 5 years only, full stop. It is true that against the said order, Civil Miscellaneous Writ Petition number 26996 of 1999 has been filed, but mere filing of writ petition would not wipe out the said action taken against petitioner, and counsel for the petitioner has placed heavy reliance on following decision, namely Badya Baidyanath Mahapatra versus State of Odisha 1989 in bracket 4 SCC 664 RC Chauhan versus UPSRTC 1991 SCD 35 and Jayanta Prasad versus State of UP and another, 1998 ALJ 239 full stop. The fact of the matter is that there is material on record wherein District Judge, Bareilly on 17.7.1995 oblique 24.7.1995 has recorded finding against petitioner of accepting bribe of rupees 50 oblique and demanding rupees 500 in suit number 14 of 1994 while working as Amin, full stop. Said order has been affirmed in appeal, also said finding is staring on the face of it, full stop. This court will not reappreciate the evidence collaterally qua the punishment which has been imposed upon petitioner by scrutinizing the evidence of complainant, full stop, para. It is true that higher pay scale has been accorded and petitioner has been promoted, but in terms of fundamental rule 56 in bracket 2 in bracket A, entries even prior to crossing of efficiency bar or before he was promoted can be taken into consideration by the authority concerned while proceeding to exercise authority of compulsorily retirement, full stop. Here, a screening committee has formed opinion and in public interest District Judge, Balia has exercised his discretion, full stop. Interference is permissible only in 3 contingencies in bracket 1. Opinion formed is malified, bracket 2. Decision is based on no evidence, third, and same is arbitrary decision, full stop. Here, District Judge Bareilly in his wisdom constituted a screening committee and thereafter on the report of the screening committee, decision in question has been taken, full stop. This court is not a court of appeal and settled ground on which order in question could be assailed are not at all available in the present case, as here opinion has been formed on the material available and said decision could not be termed to be arbitrary, full stop. Single act of petitioner touches the integrity of petitioner as he has been found guilty of accepting bribe of rupees 50 and demanding rupees 500, and same is sufficient to compulsorily retire the petitioner, full stop. District Judge, Bareilly has not taken any selective action against the petitioner, rather on the basis of recommendation made by the screening committee, action has been taken, full stop. The action taken is not against any particular individual as on the same day. 13 other incumbents have also been compulsorily retired out of 117 incumbents who were serened and attempt has been made to clear the system, full stop. Once decision has been taken, which is objective decision, there no interference is warranted, full stop, para. Learned counsel for the appellant submitted that the punishment of stoppage of 2 increments for 5 years has been set aside by the learned single judge in writ petition number 26996 of 1999, wide order dated 6.8.2013, and therefore the very basis of the compulsory retirement does not exist and the order of the compulsory retirement is liable to be set aside, full stop. He further submitted that till date, no post-retirement benefits have been paid to the appellant which the appellant is legally entitled, full stop, over.